Hello, everyone, and welcome to our group presentation on the Special Tribunal for Lebanon, where we will discuss in detail this tribunal, specifically the historical and political context that is relevant to it, as well as the establishment of this tribunal and the relevant crimes under its jurisdiction, followed by how it works, and finally, the primary case for which the tribunal was made to try. The Special Tribunal of Lebanon and the cases under its jurisdiction are heavily rooted in the political and historical context of Lebanon. In the words of the adjudicating judges, the attack on Mr. Hariri, the former prime minister, did not occur in a political or historical vacuum, and the trial chamber cannot ignore the background of the attack as it provides a possible motive for it. The accused were confirmed Hezbollah supporters, which is a military and political organization in Lebanon. In reality, it is a terrorist organization that has integrated itself into the Lebanese government, and in the early 2000s, the Syrian government was also a major influence in Lebanon's political scheme, economy, and society, and as a result ordered the continued support of the president at the time, Emili Lahoud, which would have solidified the presence of those two entities in Lebanon. Rafiq Hariri was the prime minister of Lebanon until his resignation in late 2004. However, he remained a prominent public political figure who continued to critique Syria and Hezbollah. Hariri and allies publicly called for putting an end to Syria's influence, and 3 widespread meetings were held by Hariri supporters in the end of 2004 and early 2005. These came to be known as the Bristol meetings, as they took place in the Bristol Hotel. The third and final Bristol meeting was held on February 2, 2005, just days before the attack. Now, on February 14, 2005, Rafiq Hariri was assassinated in a large explosion that also killed 21 other civilians and injured 226 people in the downtown Beirut area. The explosion was caused by a male suicide bomber who detonated a large quantity of high explosives inside a van. In the hours following the attack, a video was released on the Al Jazeera news network in Beirut, which is one of the biggest news networks in Lebanon. The video was of Ahmed Abu Abdas, who claimed to be the bomber on behalf of a fundamentalist group in Syria known as the Victory and the Jihad. This group is entirely fictitious, and this was established in the investigation that started after and continued on for years. Prior to the February 14 attacks, another politician and journalist who were both allies of Hariri were severely injured in a car explosion in October of 2004. There were 2 other connected attacks in June and July of 2005 targeting Lebanese politicians who were also critics of Syria and allies of Hariri. Each of the attacks was on an explosion of similar nature, with the suicide bomber still remaining unknown. Furthermore, the connection between all these attacks is established and based on the requirements of connection outlined in the statute for this tribunal. After these attacks, there was a formal investigation launched that led to the establishment of this tribunal.
Although the Lebanese government submitted a request to the United Nations to create an international tribunal on December 13th of 2005, the actual tribunal was only created 4 years later on March 1st of 2009, with many iterations in theretofore. Many delays and distractions were had due to the sensitivity and political nature of this investigation, including the erroneous testimony where an individual falsely took blame for the assassination, which was later proven to be impossible. In March 2006, the Security Council Resolution 1664 requested that the Secretary General should work with the Lebanese government. 1 year later, on May 2007, the United Nations Security Council authorized the establishment of the tribunal. And finally, 1 year before the tribunal was created, the investigation conducted by the UNIIIC, or the United Nations Internal Independent Investigation Commission, was concluded, and then the 10th and final report on their findings was submitted to the Security Council. Once created, the tribunal listed crimes under its jurisdiction, of which Article 1 of the STL statute states, "The Special Tribunal shall have jurisdiction over persons responsible for the attack of 14th February 2005, resulting in the death of former Lebanese Prime Minister Rafiq Hariri, and in the death or injury of other persons. If the tribunal finds that other attacks occurred between October 1st, 2004 and December 12, 2005, the parties, with the consent of the Security Council, decide if the other events are connected. Connection must include the combination of the following elements: criminal intent, motive, purpose behind attacks, nature of the victims targeted, the pattern of attacks, or modus operandi, and the perpetrators. Article 4 of the STL statute states, concurrent jurisdiction. The tribunal has primacy over the national courts of Lebanon. It is important to note that though the court has primacy over the other Lebanese national courts, the applicable law utilized is still mostly Lebanese law. Although this tribunal has jurisdiction over the events following the initial attack of former Prime Minister Rafik Hariri, the primary case to be discussed with relation to this tribunal is that of Selim Ayash and al. Finally, since the establishment of this tribunal in 2009, after being initially requested in 2005, this case has remained ongoing until August of this year, 2020.
As regards to the structure of the Special Tribunal of Lebanon, four main organs can be observed, which are the chambers, the Office of the Prosecution, the Office of the Defense, and lastly, the Registry. The chambers operate fully independent from the other three organs, as does every other organ, and it is composed by a total of 12 judges, which can be divided into four sections. The first section is the pretrial chamber. It is composed by one international judge, and his role is to ensure that the trial is able to proceed as fairly and as efficiently as possible. He can issue any orders which are related to the investigation of the February attacks, like issuing arrest warrants, transferring requests, or reviewing indictments. Secondly, the second section is the trial chambers. There are two, and both are composed of one Lebanese and two international judges. They are in charge of conducting the trial of the accused, as well as hearing the expert and ordinary witness testimony. All legal representatives, like those of the victims and those of the defense and the prosecution, must hand in all the evidence which the trial chambers must receive. They can include in their reports forensic materials, photographs, call records, etc. Another duty of the trial chamber is granting the entitled protections. For example, for witnesses or victims, they can be awarded the protection of anonymity if necessary, so holding, for example, a witness testimony in closed sessions. And of course, the rights of the accused must also be protected and upheld. The trial chamber must also decide whether the trial can be continued in absentia, which means that the person who is subjected to the trial may physically not be present during those proceedings. The chamber must decide whether one of the three necessary conditions have been satisfied, and the conditions are as follows. Firstly, the accused must have expressed the waiving of his right to be present in writing. Or secondly, the accused was not handed over to the Special Tribunal of Lebanon by the relevant state for a reasonable amount of time. Or thirdly, the accused has fled or cannot be located otherwise, although reasonable measures have been taken in order to locate and find him. Finally, at the conclusion of the trial, it is assigned to the chambers to determine the sentence of guilty or not guilty. The chambers must fully be convinced beyond any reasonable doubt that the accused is honestly guilty, otherwise he will have to be acquitted. Appeal chambers is the third section. The appeals chambers is composed of two Lebanese and three international judges. They are assigned to hear the appeals made by third parties against the judgment made by the trial chambers. They also decide over interlocutory appeals against decisions taken by the pre-trial judge and the pre-trial chamber judges on particular issues. In addition to that, the appeal judge also have the ability to raise errors of law or errors of fact. Examples of important judgments which the Chamber of Appeals has made include decisions over jurisdiction and legality of the tribunal, the trial in absentia, the joinder of cases, and the legality of transfer of call-dated records. Lastly, the Chamber of Appeals also have the ability to decide over any question related to the interpretation of legal documents provided by the pre-trial judge or the pre-trial chambers. In the duration of the trial, this has taken place in one instance in relation to the interpretation of terrorism, conspiracy, and homicide. The second the second organ of the structure is the prosecution office, as mentioned, and the prosecution office can be divided into two divisions: the investigators and the prosecutors. The investigation division is responsible for compiling and analyzing evidence in order to ensure a well-founded legal basis for the indictment trial. Investigators, forensic analysts, and experts, as well as police officers, may serve as prosecutor assistants. The state coordination and support from Lebanese as well as other state authorities is also a very vital process of the investigation. The prosecution division, on the other hand, is responsible for exhibiting the case before the court, continuously test their evidence, as well as file submissions before the tribunal. The prosecution division includes legal advisors, trial counsels, and case managers who usually have deepened understanding and much experience in the cases with such complexities. The defense office is the third organ. They are similar to the prosecution in the sense that the defense must also present, obviously, its case as coherently and clearly as possible to the judge. However, the defense counsel also ensures the protection of the accused's right and to fulfill the necessary conditions to have a fair trial. The defense team also must be independent from the tribunal and is responsible for all the file submissions before the court. Lastly, the last organ is the registry, and it is responsible for the management and administration of the courtroom. These include things like transcripts, preservation of court records, court proceedings, and so on. And they are also, at an international organizational scale, responsible for legal advice, financial advice, and human resources. Now, lastly, I want to talk about some unique features of this tribunal. And firstly, it is important to note that it was the only international tribunal which allowed crimes to be tried under national law. This is where the crimes in abstentia become relevant, as they are part of the Lebanese national law, which allowed them to be applied in this tribunal. And secondly, it was also the first tribunal of its kind to deal with terrorism as a distinct crime, which terrorism was defined under customary law and also as an international crime for the first time as a result of this tribunal.
The Special Tribunal for Lebanon revolves around one situation, which are the attacks of February 14, 2005, when President Hariri of Lebanon was attacked and killed by a suicide bomber. Now, the Special Tribunal for Lebanon brought 4 accused for responsible in conspiracy and execution of this assassination. The first one was Salim Ayash, second, Hussein Hassan Onaisi, third, Hassan Hassan Sabra, and lastly, Mustafa Amin Badreddin. Now, these 4 were alleged, first, Mr. Ayash to have been assassination team coordinator. Mr. Badreddin was the monitor and coordinator of the overall conspiracy and labeled the leader of the group. Mr. Onaisi and Mr. Sabra had lower positions and were seen performing only supporting tasks for the assassination. Overall, the main attempt of the prosecution was to prove that this was premeditated, and they were looking into the use of telecommunication networks to conduct surveillance on Hariri, and they alleged that Hariri had been surveilled and followed for months prior to the attack by the 4 defendants. The other main goal of the case was to establish this case as an attack of terror, as more than half of the 22 killed by the explosion, other than the suicide bomber, and almost all of the 226 others who were injured had no connection to Mr. Hariri's conduct. Therefore, the STL brought on 9 counts of charges against these 4 defendants in total. However, only the first count was applied to all 4 of them. Now, the first count was conspiracy aimed at committing a terrorist attack. Now, in this case, the court looked at the surveillance, and they found, for example, that there was organization and deep surveillance into Mr. Hariri. And they also identified that they had found the uses of a suitable individual named Mr. Abu Adas to make a false claim of responsibility in a video for the attack on Mr. Hariri, and then to afterwards deliver the video to a broadcast network. Therefore, it was found, indeed, by the courts that there had been a case of conspiracy and premeditation towards this assassination. Now, counts 2, 3, 4, and 5 were brought up against the two main co-conspirators, Mustafa Amin Badreddin and Salim Jamil Ayash. Count 2 was committing a terrorist act by means of explosive device. Count 3 was intentional homicide of Rafiq Hariri with premeditation by using explosive materials. Count 4 was intentional homicide of 21 persons with premeditation by using explosive materials. And count 5 was attempted intentional homicide of 226 persons with premeditation by using explosive materials. Now, for the count 6, count 7, and count 8, and count 9, they were attributed to Hussein Hassan Onesi and Assad Hassan Saleh, who were found to be lower in the conspiracy and were attributed accomplice charges to the same crimes as count 2, 3, 4, and 5. Now, before the court, they found that the trial chamber was satisfied beyond reasonable doubt that the explosion was in fact intended to cause a state of terror, and that despite Lebanese law not defining a state of terror, but the interpretation of Article 314 convinces the trial chamber that the foreseeable consequences amounted to a state of terror. Now, there were aggravating circumstances, such as death and destruction of buildings, and Article 6 of Lebanese law. For the intentional homicide, the actus reus is that the act or omission is a cause of the person's death, and the aggravating circumstance was the use of explosive materials. And then the trial also brought in the attempted homicide of the 226 injured, and the chamber found that they were fulfilled as they executed the necessary acts or omissions completely, except that those people did not die, and that these were due to circumstances beyond the perpetrator's control, preventing their death. And they also had the aggravating circumstance of the use of explosive materials. Regarding the judgment and the overall consequences of this trial, the official judgment was released by the STL in 2020, and it only found Salim Ayash guilty while acquitting the other 3 defendants. It held beyond a reasonable doubt that Salim Ayash had conspired with people and that they had followed Mr. Hariri for months. They also held beyond a reasonable doubt that they had prepared an explosive device and led the assassination team on the day of the killing. However, the involvement of the others was not proved beyond reasonable doubt. The other main co-conspirator, Mustafa Amin Badreddin, died in 2016, and he was therefore not charged with anything, as they did not find sufficient evidence to hold him liable post-mortem.